First matter to come before the court this morning is Equipment Engine Financial Services. The parties are here and in place. As you know, each party will have 15 minutes to present a little argument. The appellant proceeds first, and you may let me know if you wish to reserve any time for rebuttal. I will be keeping the time. So we have read the briefs. If I can get my iPad unstuck, we'll proceed. Yes, we're ready.
Thank you. May it please the court, counsel, my name is Tom Lemp. I'm here representing the appellants in this case, Mike Service Center. You read the briefs. It's a fairly simple case that we're dealing here with. I'm sorry, I would like to reserve 5 minutes. My apologies. It's a fairly simple case here. Mike Service Center was in need of funds and was not getting his monies basically in the pace that he wanted or needed at the time for paying all his debt. So he did what a lot of businessmen do in this situation, is they go out and try to find some way to find money. In this situation, the purpose, what happened was you sell your receivables or some portion of your receivables in exchange for receiving some money up front. Something like akin to a loan or something of that nature.
Exactly.
So what happened is he did that, he got into a situation, then that First Data, which is a processing company, was supposed to be just that, just a processing company. What they're supposed to do with First Data is they're supposed to provide, for the machines out at the pump or what have you, it's a gas station. The money, they put the card in, First Data gets its percentage, the balance of the funds go to my client. After, in this situation, they owed some money to someone else, Rapid Capital, for a loan, okay? Long and short of it is, a phone call comes in or a letter or what have you comes over to First Data saying that Mike Service Center and Mike McTarian have stopped making payments on their loan, freeze his account, freeze basically his box, so to speak. Make it so he doesn't get any of the monies. We want to get these monies.
What was the relationship? I don't think it's really clear in the brief between MSC and First Data, if any, or between Rapid and First Data.
The relationship between MSC or Mike Service Center and First Data is basically that First Data has a relationship with HNB. I apologize, we're both do this. That's why I write Huntington and PNC, the old National City Bank, okay? So that's where that relationship comes from. The relationship, the other, is basically that First Data was sending money to them. To our knowledge, there's no other relationship. I don't know of any of the discovery, what I've seen in the files of this. I was not counsel over the trial court, at least early on. But the long and short of it is, when they get this telephone call or the email, the letter, whatever they get, what did they do? Well, that's in October of 2013. They freeze the account.
And the letter said that Rapid had a security interest in all his assets.
Right, we have a security interest in all his assets. He's not making payment. This is now one of the assets. Now, of course, no one does anything that one would think, we think in normal business would be the prudent thing to do. Check to make sure whether that's true. Get a copy of the contract. See what you have. The contract that we're dealing with here, the Rapid Capital contract or the Equipment Engine contract, or whatever you want to call it, the original contract, is signed by one party and one party only. It's only signed by MSC, Mike McTarian's company. Mike guarantees it. It's not signed by the other party. This is where it gets interesting. We've all seen the argument many times. In fact, I'm over there with the same issue and the summary judgment issue of Rapid Capital right now, that only the party to be charged has to sign a document. We've all heard that many times. Well, that's not true always. Here it's not true. Their own document says that it's only a contract, it only becomes something chargeable, only something enforceable upon the signature of all parties to the document. And the document that they provided in discovery, the documents that's been provided, they don't have one signed by them. They never signed it. And then you get to other interesting things which are not necessarily part of this problem here, but are related to this problem here. You know, if Rapid Capital is owed money, or whatever name it's using at the moment is owed money and claims that, geez, First Data, you go jump on this, you have to look at their contract about what they can do, what they can't do. According to their own contract, not signed by them, so it's not a contract, there's no relationship, obviously they just take money, apparently, but whatever. If they had anything valid, and if it was a contract, they have to pick up the phone. That's what it says. It says, if there's a dispute, one party has to call the other party immediately. We have 30 days to work it out to mediate it. If we don't mediate it, then we have binding arbitration. And it was according to it was the AAA, American Arbitration Association. And you know what happens then if we don't do that? We can file suit. We can file suit against you in small claims court, which not how this lawsuit started, because it's a lot more than small claims court jurisdiction. Or if not, we can file suit in a court of jurisdiction in the state of Florida. And it's what, about 12 or 14 degrees here today, so we're not in the state of Florida. So the underlying contract that caused the problem, or the underlying company that caused the problem, that caused First Data to do something that First Data never checked on, and never said, we need proof of this before we hold this man's money, before we hold this company's money, has done nothing in accordance with the, quote, agreement that they claim is in place that gives them the right to do this, that gives them the right to take all this money. So,
well, you make it sound like, you know, they're taking all this money, they're just taking money. Well, you know, the brief says like suspended deposits to the business bank account.
correct.
So they were obligated to pay that. It wasn't like it was, they were just giving them money, right?
Well, he was obligated to pay it. He believed, pursuant to a loan agreement that he thought he had with somebody who didn't ever provide him money, and did not ever provide him a signed contract for it. This is a commercial agreement with a company from out of state who is supposedly in the business of doing this and supposedly knows what they're doing and drafts their own agreement. And in doing so, one would think they would follow the agreement, and the first part of following that agreement is, prior to giving all this money in a loan, or giving access to these funds as it may be, signing the contract in accordance with their agreement. And they didn't do that.
So First Data puts the money in an account?
First Data then holds the money. Instead of, you know, like I said, originally with First Data, you know, I have a credit card thing I use on my phone. I checked the other day with PNC, and they told me First Data is providing this for you. I was thinking, okay, well, that's why I thought, because there aren't many companies nationally that do it, to be fair, okay? And I thought, okay, that's probably who I have. And that's what they do for a living. They do the technology that provides the money going off to whomever it goes to.
And they gave notice to MSC that we're setting aside this money in an account until either you work things out with the other party, or a court order.
Or a court order comes in, correct. But like I said, what they didn't do was they didn't check to see whether they had a valid reason that they could set this money aside in an account. They didn't do that.
So the court ordered pursuant to, I don't know, some kind of...
TRO. Yeah,
Yes.
basically
Ordered
TRO.
them to release the money, and they did it.
Right, they did that. There's no question they did that. And I don't think there's any question that they did it in a timely manner issue. I mean, the order was on February 4th, 2014. I don't know off the top of my head what day the money came, but I've heard no complaints, which leads me to believe it was very quickly, which is typically how that works when something like that happens, especially if someone says subject to. But there was no reason that should have ever happened, and that's the first problem here. I have a second assignment of area we're dealing with. Obviously, our position is the summary judgment was not proper, as there at least is some argument. I understand the court below said, well, geez, he got all his money. Well, yeah, he got his $12,000. He didn't get all his money. It's a gas station, and I know personally, as I see other people do this now, where you pull up, you put your credit card in the machine, and if it doesn't work, I can vouch for what I did a few days ago. I was going to Columbus, and I pulled the car out, and I drove across the street to another gas station whose machine was working. Because when you have a lineup at the store or not have a lineup at the store, it's a hassle to go in or out. And if you have kids in the car, there's safety issues.
Well, the complaint, as I read the briefs, alleged that First Data stopped him from using the credit card machine, when that's really not the case.
Technically speaking, they didn't stop him from using the credit card machine. Now, I'll admit that. Like I said, I did not draft the original complaint. I was not involved at the time. Technically speaking, that's true. But this is akin to an employee saying, I was fired, when you look in the piece of paper and it says that the person resigned. It's akin to that same sort of situation here, that many times when someone resigns, they didn't really resign. They were forced to retire, forced to leave. Here what we have is a situation, this is a mom and pop's business, literally. This is on the Talmadge Circle there. Mike McTerrian has been there probably for over 30, 35 years now. It's a successful, small business. And what I mean by successful is they're able to pay their bills for the most part, their personal bills and their business bills. It's not something they're not a BP or someone like that. But what we've got here is a situation with, if that machine isn't being used outside, because he's not getting the money, he's not getting the money, he's going under at that point. So he has to make a decision. What am I going to do? So he goes and he gets a handheld little squared thing that you put on your phone. It's not convenient for your customers. They have to come inside now, and as we all know, people don't do that much anymore. They try to use the machine outside, and a lot of times they leave. And then, of course, you're losing other business too, because, I'm sorry, Mike 5?
Yes.
Okay, thank you very much.
Good morning. May it please the court, my name is William Stassen, and I represent First Data in this appeal. I wasn't sure if there was a particular place you wanted me to start, but let me just respond to a few things that were addressed in the beginning. I just want to make sure the court is clear that when counsel is talking about agreements not being signed, counsel is talking about the agreements presumably with the plaintiff in the case, which is not First Data. That's Rapid, that's what he's talking about. The agreements that are at issue before this court were clearly signed, and those are part of the record. Those particular agreements were signed. There were two of them. One is with Huntington and one is with PNC. And in the complaint, what Mike's is complaining about, they say they have two issues. One is they take issue with the hold that was put on the account, the processing account. And the second is that they say they were unable to, or refusal to process more transactions. And just so the court's very clear, there was never a denial of, I'll call it Mike's Service Center's ability to process credit card transactions. In fact, the record is clear that transactions were continued to be made on a more limited basis after the hold was put in place. That's undisputed in the case. So there was never a prohibition against using the processing services that First Data provided. I don't know if it would be helpful, but let me step back just a little bit and explain how this processing works. So basically what happens is you have a lot of banks all over the country. Most banks don't do the actual processing of your credit card transactions. So what they do is they have an agent, in this case it's First Data. There are many such agents who actually do the processing. So when someone takes a credit card to a store and you put it in the machine, almost instantaneously the processor determines, do you have enough credit to make this purchase? And then all these things happen behind the scenes to get that money to the merchant. All of that's done by First Data. First Data takes a minuscule time, less than 1%, like a fraction of 1%, is sort of the fee for processing for the bank. So the First Data is truly sort of the vehicle through which all these transactions happen, but it's not the bank. So in any case, the agreements that were in place, and they're in the record, they allow a reserve account to be set up. So this complaint about a hold being put in place The agreements which Mike's Service Center signed allow for that. And specifically, just to direct the court to that, in the two agreements, one in the Huntington agreement is section 24, and the PNC agreement is section 17. And those are both attached to the summary judgment motion, which was filed in the court below. And what those clauses say is, to the extent that the processor determines in its sole determination that it may be subject to some risk, it could be fraud, it could be a lot of different things, it can set up a reserve account so that once the money goes out the door, it's very difficult to get it back and figure things out. So here, a third party, Rapid, contacts First Data and says, we have a valid UCC over all of the assets of Mike's Mike's Service Center, and we demand you give us whatever money is there. So First Data is put in this difficult position between Mike's Service Center and Rapid. And so what First Data does right away is it contacts Mike's Service Center and says, look, we have this UCC demand. We're going to take the money, that there was $12,000, we're going to put that in a reserve account. We're going to hold it until the two parties can figure out who owns it or a court determines it.
And the $12,000 figure came from where?
That is how much was sitting in the account at that very moment when the UCC claim came in. Now, presumably that amount may have gone up a little bit because I said there were additional transactions that happened after that whole thing was put in place. But that's all that happened. The $12,000 was put in essence in reserve. Sometimes parties might say, we'll put it into court. There's a dispute over who owns this money. We'll just put the money into court. Or sometimes you put it in an escrow account. Well, here they put it in an escrow account. Obviously, there was a TRO filed. The court determined that the money should be given to Mike's Service Center, and that was done. So if you just look at the claims that have been asserted here, one is breach of contract. So Mike's Service Center itself agreed there's a contract between First Data and Mike's Service Center.
Because they agree that First Data is an affiliate of PNC in Huntington, or for other reasons?
Well, I don't know why they specifically agreed, but within the documents you will see, within the record, Mike's Service Center, both in their complaint, they admit that or state that First Data is their processor. They also, Mike McCarrion, I'm not sure if I'm saying his name right, but in his affidavit he says it as well. First Data is my processor. In his request for admissions responses, he admitted that the two agreements attached to the summary judgment motion are the operative agreements. So I can't get into his mind and say why he admitted it, but that's undisputed.
Well, what is First Data's position as to, are they in privity with Mike's, or are they acting just as an affiliate of Huntington and PNC?
First Data? First Data is, I wouldn't call it an affiliate because that has a specific definition in the agreements. What they are is a person. Person is also defined in agreements. So First Data is a person who those banks chose to process their transactions.
First, Merchant Card Services could have been contracted by the banks to do it as well.
That
could change at any time, First Data.
That's exactly right.
Okay.
That's exactly right. And the contracts also say specifically, in the Huntington agreement is section 38.8, and the PNC agreement is 31.8, that whoever the bank gets to do this process is a third-party beneficiary of the agreement and can enforce its terms. So that's a specific term in both agreements. So here, First Data is that person who actually did the processing for the banks. So there should be no dispute based on the contract language that First Data is in fact a third-party beneficiary. I can read the language if it's helpful to the court, but...
I think it's in here.
Okay. Thank you. Just touching on the other claims, that's sort of the breach of contract claim. There was also an unjust enrichment claim and a conversion claim asserted against First Data. With regard, we believe the lower court got it right with regard to unjust enrichment. Clearly under Ohio law, Supreme Court, unjust enrichment is not about compensating for damages. It's about returning the unjust compensation that the defendant received. And here, First Data received no compensation. They simply took the money, put it in a reserve account until someone could determine whose money it belonged to, Rapid or Mike Service Center. No unjust enrichment claim. And same with conversion. As the lower court ruled, it wasn't clear whose claim was going to be superior with regard to this $12,000 sitting in the account. So there wasn't a clear ownership interest at that point that was clear to anybody. But secondly, I would submit that First Data didn't act with dominion and control over this funds. It's not like your typical conversion case where someone claims something as their own, and then you say, wait a second, I'm suing you in conversion. You have to give me the value of that thing which you've now said you own. We didn't do that. We didn't say we own it. We didn't put any dominion and control over it. We just put it in a reserve account. And once the court determined whose it was, we turned it over. So also in a conversion case, normally, you give the value of that which you converted, which here would be $12,000. The $12,000 has already been returned. So there would be, even if one could make out a conversion claim, there would be at this point no payment due and owing from First Data with regard to a conversion claim.
Once the $12,000 was placed in a fund, did your client have access to it?
Well, they control the account, but my understanding is they did not access it or spend it or get interest out of it.
I'm thinking,
Yeah.
in terms of having control and
Your Honor, I don't think they took that money and put it in a bank account, like a separate bank account, saying, hey, whatever, PNC Bank, hold this $12,000 for us, put it in this account. They put it in an account. I mean, they got many accounts, but they took this $12,000 and froze it and said, okay, this isn't going anywhere until someone tells us who owns it. Does Mike Service Center own it? Does Rapid own it? Either come to an agreement between you two parties or have the court tell us, which is what ultimately happened.
The contract between Rapid and First Data, is that contract part of the record as well?
I'm sorry?
Rapid and First Data.
I don't believe it is part of the record in this appeal, but presumably, honestly, it may actually be. I didn't focus on that so much. Actually, I believe in the response to the motion for summary judgment, I believe actually they did attach the various agreements, or at least some of the agreements between Rapid and Mike Service Center.
Well, I guess the reason I'm asking is I'm wondering under what authority who contacts First Data to say, hey, look, we got a problem here and you need to put this money in a reserve? What does the contract between Rapid, who Mike's owed the money to, and First Data, who held the money? I'm wondering what kind of relation, I know what the relationship is because we're talking about it, but on paper, what authority does First Data have to respond to Rapid and freeze the funds? That's what I'm asking.
Yeah, I don't believe that there is a contract between First Data and Rapid.
That's a part of this case.
Right.
Well, surely there is, but it's not part of this case.
Well, I think what happened is, First Data is, it's like 1 billion transactions a day. I mean, there's so many transactions that are being processed. And they get a letter from a party who says, we have a valid UCC, it's been recorded, whatever funds you're holding for this Mike Service Center, we own. So, the legal department of First Data says, uh-oh, we got a problem. We've got $12,000 in the account. We've just been contacted, someone saying that we have a valid UCC, it's now ours. We have a priority over it. That's, our priority is now superior to Mike Service Center. So the customer for First Data is Mike Service Center. So what First Data did was it immediately sent a letter to Mike Service Center and said, we've been contacted. Someone says they have a UCC over all your assets. We're putting this we're putting this money in the hold. Someone tell us what to do.
is there something in the record to indicate Mike's response? Because I understood that this was by either letter or by email, the notice
Right,
from First Data.
yeah.
Do we have a response from Mike's in the record?
In writing, I don't believe so, but I could be wrong. I will check on it.
You have about 1.5 minutes.
Okay. I don't, I really just want to address the court's questions, so I don't feel the need to just talk to talk. But if the court has any other questions, I'm happy to respond to those.
Definitely not.
All right, thank you very much.
Thank you.
I appreciate your time and attention.
We have just under 5 minutes.
Thank you, I'll be brief. I want to talk just very briefly before I get into my assignment of error number 2 about what counsel just talked about, the conversion claim, and the claim that, we gave you back the money, therefore there is no conversion. What they're forgetting about is the damages in a conversion claim are not just the value of the asset that's been taken, the $12,000. It can be other damages too. Here, we've indicated, is indicated in the briefing, is indicated below. In the gasoline business, one of the things one of the big areas you're making money in nowadays is the other products that you're selling. And if you're not selling gasoline because people are not coming to your pumps because they're not using your machines, they're not buying these other items, they're not coming into your store after they're pumping or while they're pumping or something of that nature. So you're missing out on that first of all.
Would you consider that to be lost profit?
I would consider it to be partially lost profit, also just other lost sales, lost revenues.
One of the agreements that your opponents listed in the brief directly
Talks
relates
about
to
lost
that and
profits.
says, you can't go after that.
Well, that's if you're talking about going after PNC or H&B. You have to remember, PNC and H&B have a contract with my client. My client has a contract with this equipment engine or rapid, may or may not have a contract with equipment engine or rapid. My apologies, there's a document, let's call it that. They don't have a document with First Data. First Data is in a situation, like I said, they basically moved based upon someone telling them to do something. And when they're saying they put the money into something akin to an escrow account, they really didn't put it into an escrow account. When you put it into an escrow account, you have escrow instructions that everybody agrees to. There would have been something at that point written and signed by someone on behalf of Mike Materian and his company, and there would have been something on behalf of Rapid Capital at that point, and saying, okay, whatever happens here with a court or something else, a third-party decision or something, then the monies go to A, B, or some combination. That's how that works. This money was still in their this money was still in their possession, still in their control. Bless you.
Excuse me.
So they had the ability to make any decision they wanted to. They were still converting it. They were still wrongfully holding on to the monies. Just keeping that in mind.
And very quickly, your understanding of their authority to hold that money did not have anything to do with their position as it related to the banks, solely because they received the UCC filing?
Just because they received notice of a UCC filing, they still have some obligation to investigate and to determine what the veracity of that is. Otherwise, on their theory, anyone who sends them anything that looks like a UCC filing, and as judges, you see these things or have heard of these stories, I'm sure, where people file fake UCC filings or provide fake UCC filings claiming that Judge so-and-so owes me $2 billion, for example. That's happened in several states. I would hope that First Data wouldn't just honor that, and I would hope that First Data would ask, can you provide us this information? If they're going to put a hold on the funds, let's say, on October 13th or 14th when it happens, you would think that shortly after that, they would have that worked out. They would, if someone's able to provide you this document, why can't they provide you the next document? So if there is going to be a hold, it should be a minuscule period of time for the automatic, okay, show us what you have, what's your documentation, how much are you owed, when were you owed the money, what's this? Something that easily Rapid Capital should have been able to do, or Engine Equipment, or whoever is doing it at the time should be able to do, because that's what they do for a living. So, talking about the other types of damages that we're talking about in a conversion claim, attorney fees are recoverable in a conversion claim. Punitive damage is a recoverable conversion claim. None of that, there was no opportunity given for that. I'd like to talk very briefly about the second assignment of error.
You have 30 seconds.
It's kind of the overlooked assignment of error. The claim is that someone else was going to file an answer for us and take care of us. The claim is someone else was going to care for us. Well, who's that someone else? They've identified as someone else, and they claim that they have an obligation to provide them some, provide service to them, Rapid Capital, and Rapid Capital doesn't do it. If you look at the case law with respect to reliance on a third party, it's quite clear now, and it's quite easy now to determine whether you have been protected or not. Thank you very much.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and will issue a written opinion, which will be sent to both sides and will be posted on the Supreme Court website.
Thank you.
Have a good day.